Good morning, everybody. Thank you for coming. I'm Ricardo. This is Fernando, Sara. There's a lot of people from our team here. Today, we're going to talk about the changes that affect the local lodging in Portugal. Most of this is bad news, so I'm really sorry that I'm going to spoil your day. But don't shoot the messenger. We just think that it's important that you are aware of what's coming, so that some of you may take decisions or that are aware of the consequences in case you don't take them. So basically, this is about the law package that they called Mais Habitação. We're going to talk about the main measures of the law package. Talk about the changes to the local lodging laws, which is what most of you are here for. The new residential rental taxes. We're going to just show you briefly the income tax, a comparison between the AL, which is a local lodging, and the residential rentals. Rental options in case of no AL license. The new capital gains tax exclusion. Give you some examples about the capital gain tax when you have AL and when you don't have AL. It's very important. It's very important that you always plan before selling, because it could be very expensive when you sell a business without planning. And then we will have questions and answer at the end. So basically, about the law package, we just resumed here what the government is trying to make. As you are aware, there's a house crisis in Portugal. It's not only in Portugal, it's everywhere. It's in New York, it's all over the world. And they claim that a lot of that is related with the Airbnb. I don't know, but what the government is trying to do is to make a lot of restrictions on AL and try to move people from the local lodging, the short-term lets, to the residential lets, to try and get more properties available. They are restricting, in most cases, apartments. So villas, they are not affected. And when I mean villa, it's an independent unit. Because sometimes if you have a townhouse within a condominium, that's also one of the restrictions. So it needs to be an independent house. So basically what the government has came with, these are the main changes. The golden visas, which before people would just come and buy a property and get the golden visa, that's no longer available. They have different golden visas, so you can have the visa based on investment on a company, if you create jobs, if you invest $500,000 in a company, if you do something related with research and development. But the old days where you used to come and buy a property to get the visa, that's no longer possible. Obviously, the government thinks that that was one of the things that were making the property price be more expensive. There's limits to rent increases on new lease agreements. So the government, for those that have rentals, they every year they've been limiting how much the landlord can increase. They have a new measure of forced rental on vacant properties. So anyone that has a property which is vacant for 2 years can be notified by the government to force the rental. Don't get scared with that part, because it means a vacant property is a property that there's no rental, there's no electricity contract, there's no consumptions, no water for 2 years. And if in that case, if the property is in that condition, the municipality can notify you, and then you have 90 days to justify why the property is vacant, or you will be forced to give it to the government to rent it on your behalf. We're going to talk about the restrictions to the AL. It's one of the main measures of this law. There are also some support for the promotion of affordable rental for habitation purposes, which means that in certain situations, you will get an incentive to rent it cheaper to people that need the house to rent. To be honest, it's not attractive, and I think that it will fail. there's a creation of a new institution, which is a tenant and landlord counter, to deal with eviction processes or people that don't pay. So they are creating something to expedite the process, because one of the problems in Portugal related with rentals is that if I rent my property to someone and that person doesn't pay, we all know that it can take a long time for me to get that person evicted from the house, and I might not get the money back. So they are creating this. Hopefully, this will work to expedite that process. So instead of going through the court, it will go through a special court, let's say. It's like already exists for other situations. And there's also a state's guarantee in case you are renting through one of the governmental programs, that they can guarantee the payment if the tenant doesn't pay. But this is for long term, and again, it's only if you rent at below the market value, because you would have to rent according to the index that is published by Portugal for each municipality, and obviously the amounts are much lower than what normally you would rent in the open markets. So these were the main measures, and let's talk about the changes to AL, which is unfortunately what we are here to talk about. Don't shoot the messenger, okay? So as of the 6th of October, this law already started, so it was already published. Someone was asking me, I don't know if you are aware that the Portuguese Prime Minister resigned a couple days ago. The president is supposed to talk tonight, and we will know if that resignation will be with immediate effect or if it will be at the end of this month after the state budget is approved. Regardless of what the president will decide, this law was already published, okay? So this is already an effective law. There are some things on the law that that are not decided yet, but the law in itself, it's already approved and published since the 6th of October 2023. So these measures are already in place. So, and that means that, for instance, the first measure is that if you just bought an apartment in Tavira, you cannot have an AL license, okay? So you just bought the property now, it's an apartment, you cannot have an AL license. So only the AL license that were issued before the 6th of October 2023 are valid. And the only exceptions, if you buy an apartment in Portugal, for you to get a rental license are the islands, Madeira, Açores, and the inland territories. So all the coastal territories, basically they are forbidding for apartments to obtain a rental license. In the Algarve, the only places where you could have an apartment with a rental license, a new apartment, a new rental license, would be Alcotim, Algesur, Castro Marim, Monchique, Vila do Bispo, which is Sagres. And then within Lolé, there are a few places where you could still have a rental license in an apartment, in Silves and in Tavira, so Cachopo and Santa Catarina Fonte Bispo. But as you can see here, all these, normally there are no apartments here. I don't know any apartments in Cachopo or Santa Catarina de Fonte Bispo because they are inland. So the fact that they are inland territories and that you can get an apartment there are no apartments. So so what they also said was that anyone that has a rental license, which they consider inactive, the rental license will be cancelled automatically by the government on the 6th of December. And what you have to do is, and while we already emailed our clients, is we need to prove that that license is active. And the way to prove that is through the government website, confirm that you have rental activity, submit the last tax return if it's available, or VAT return if it's available. And this needs to be done for all the licenses, irrespective if it's a villa or an apartment. It needs to be done for everyone. The new law also states that the transfer of rental licenses is no longer available. This is something that were already in place. We have a client here that has an apartment in Lisbon. That was already not possible over the last 2 years in Lisbon because there are containment areas where you cannot do this. So what the government is doing now, it's all over Portugal, it's not possible to transfer a license. So if I sell my property with an AL in Tavira, I sell it to somebody else, that person cannot use my license because the license is now null and void. Even if I own a company that has the license, if I sell 1% of the shares of that company, the license is also canceled. I don't know how they're going to check that, but in the personal circumstances, it's very easy for them to check because the register, it's done in the name of one person, which is the owner or the person that is exploring that unit. And if the person sells that property, the new owner won't be able to get the license if it's an apartment, okay? All the rental licenses now are also only valid for 5 years. This is something that in the past, there was a term for the licenses. I remember a few years ago, when we started with the AL, the license was valid for 10 years. And then the government changed the law and they said, the license is for life until you sell the apartments. Now what they are saying is, hold on, the license is only valid for 5 years. So all the ones that have a rental license at the moment, the rental license is valid until 2030. And in 2030, you will have to reapply or submit to renew it. The only exception is those clients that have mortgages, which if you bought a property with a mortgage and you had an expectation of doing that investment and you were expecting to have the rental revenue, the government allows that license to be valid until the mortgage expires, because it would be very unfair. I just made a mortgage on my apartment and now I cannot rent after 2030. So they allow that. It's the only bit that they seem to be sensible, but at least that. So, yeah. If you got your license just now, we will have to submit proof of activity registration. That's the only thing that we have. We have many clients that registered for AL. They were doing works on the property. They never invoiced it for clients because the property hasn't been rented. Some of them not even have the AL because they are waiting for the works to be finished, and we can only apply for the AL after the works are finished. In those circumstances, the only way to have an evidence that you have an activity is that you register that activity at the tax office. So that's what we're going to submit.
You've referenced apartments on the one side and detached villas on the other. What's the situation with regard to semi-detached properties or linked villas?
Normally, linked villas, they are not isolated, so they are the same as an apartment. The only way for me to answer that question, I would need to see your tax register, which is the caderneta predial. And then in the tax register, if it says moradia independente, that's a villa and it's not affected by this. If it's in most cases, if there is a condominium, if they are linked, in many cases, it's a fraction. So it's like what we call horizontal property, right? Do you know if that's where is your property? Sorry.
Castro Marim Golf Club.
Yeah, but Castro Marim, it's not. It's one of the exemptions.
Yeah, but there will be other bits of legislation that apply, won't there?
Castro Marim, it's on the list here, and it's exempt from this issue, which means that anyone can have a rental license in Castro Marim, anywhere in Castro Marim, and because of the fact that they are exempt, they are also not liable for the CEAL tax, which is something that everybody wants to know, okay, and that we will talk about. The CEAL tax will not be applicable to apartments within these councils.
Ricardo, you said that everybody has to justify the activity. So I tried to go to the site yesterday, and this is what I read on the site. Sorry, it will be in Portuguese,
No
I'll
worries.
translate. Se a atividade do alojamento local for desenvolvida em habitação própria e permanente e não ultrapassar 120 dias per ano, não é preciso comprovar a atividade. They say it's not necessary to do this comproval if you do it in your own house less than 120
Correct.
days.
If
I'd like to
you
clarify
are,
that point.
So we need to do it for everyone. When the house, when you have an apartment and you have the AL license, but it's your main residency, and by main residency, it's a tax residency. When it gets to the next stage, it says you don't need to prove it. So we need to go there to the website, but then we don't need to submit any information. We just need to tick a box and say that this is your main residency. And in those cases, it's possible, even if it's an apartment, to continue renting. So as long as you don't rent for more than 120 days per year. Okay, so what Dennis was saying is, I own an apartment. The apartment could be anywhere, could be in Tavira. If I live there, it's my tax residency. I can rent it up to 120 days. So I can get a license to do that. So even if I don't have it now, I can get a license. So it's not affected. And it doesn't pay the extraordinary CEAL tax. It's one of the measures that we were going to talk about. So the exceptions are all these inland territories, but also when you have the apartment as your main residency and you don't rent it for more than 120 days per year. Okay? Noor, over there.
If we have a residence in the Algarve, it is independent, but it's not our primary residence, but our secondary resident in Portugal. Can we still have an AL license?
In your case, you can have the AL license because it's not an apartment. If it was an apartment and it was not on these territories, you could not have the license. But in your case, because it's not an apartment, it's not a problem. But if it was an apartment, it's a secondary habitation.
Okay.
Even if you already own it and you thought that you were doing some works and now getting the AL license, it's not possible.
Okay, but if it is a secondary resident, it's still possible?
It's still possible because it's a villa. So villas, it's not a problem. And obviously, if it's a linked villa, we need to check what it's on the tax register. There's also more powers that were given with this law to condominiums. So nowadays, if you have an AL in a condominium, the condominium assembly can say that you can no longer have the rental activity. So I'm just starting with this point. So if 2/3 of the owners of that flat of apartments say, I don't want more ALs, they can cancel the ALs. Even if all your guests behave very well and if you never had any troubles, or if, for instance, there is one guy on the first floor that has an AL which creates all the problems and they want to stop that AL, they will stop all the ALs in that block, okay? So now there's more power to the condominium. The condominium can, if 2/3 of the owners, but the 2/3 need to be on the General Assembly. It cannot be 2/3 of the people that normally go to the assembly, which normally only goes 2 or 3 guys. So it needs to be 2/3 of the owners, and they need to be there. And by owners, it's the square meterage, because the owners have votes based on the square meterage of their units. So that's the second point here. So they can request the cancel of the AL activity. On the first point, in the future, if you are trying to get an AL, this will only be possible if all the condominium already approve that the AL was possible, okay? So let's forget about Tavira, because we know that Tavira, it's on the blacklist. But let's talk about Castro Marim, for instance. I have an apartment in Castro Marim that I just bought. For me to have the AL, I need to have a minute from the General Assembly of the condominium saying that AL, it's allowed in that building. So even if I bought the property in Castro Marim, it will only be possible to get the license on that apartment if the assembly of the condominium allows for it. So that needs to be done prior. There might be some condominiums that when they are built, they already have that license. So I think that in the future, there will be some condominiums that while they are being built, they will get a touristic, I don't know the exact term, but they can get a document on the constitution of the condominium saying that the local lodging is allowed in that building. Okay? Another situation, the condominium can vote in AGM that the rates for those that have local lodging can be higher than the other people. So they can decide, you have an AL in a flat of apartments where all the other people don't have AL, and they can say, okay, you need to pay more condominium because your guests use the elevator more often, or they don't need to give many reasons, they just need to decide. And if they decide, you can pay up to 30% more than someone else. Question?
Also apply if you rent out your apartment less than 120 days.
This applies to all of them. Anyone that has an AL license, even if you live in the property, in the apartment, because you have an AL license, they can say this. They can force you to pay more. Okay? Not okay, but.
Sorry, yes, the 2/3 vote is at any time.
Anytime. They will need to call an AGM and say, we want to get this. It cannot be aside from the convocatoria, from the announcement that they make when they call for the AGM. Normally there's AGM for approval of the accounts and for the budget for the following year. And normally they do all at the same time, and they have another line which says any other subjects, where they discuss the things on the building. They need to call an AGM where one of the points is to stop the AL, and they need to have 2/3 of the vote. So if I'm voting and I'm not there, I need at least to give a power of attorney for someone that will be representing me. Okay? So this could be critical, because what the law was saying at the moment until the 6th of October was, if I have an AL on my apartment and my guests are making a lot of noise and they are creating problems and they are destroying the public areas, all the other people on the apartments, they would have to make a complaint, and they would have to show to the council that there was a valid reason, and the council would suspend my license for a period of time. But that was fair. I mean, my guests were creating the problem, so it was fair that I would be punished for that. What they are saying now is that even if the guests are the nicest ones, and if you're doing everything correctly, if someone doesn't want, or if your neighbors don't want you to have the AL, if they have 2/3 of the votes, they can just cancel your license. And then if they cancel your license again, what happens is you cannot get a new one, because in Tavira, for you, if my apartment, it's with AL, and they vote to cancel the ALs on that block of apartments, I cannot get another AL license until 2030, because it's suspended in this area. And that's why it's important that people realize that nowadays, if you lose your license, you might not be able to get a new one. And one of the reasons to lose it, it could be the condominium, it could be because you're not registering properly the tourist taxes. For instance, Olhão, the municipality yesterday has signed a press release saying that don't forget to register your activity before the 6th of December, but we are also pay attention to the touristic taxes, because if you don't register, that's one of the reasons that you can lose your license. Another reason for you to lose your license is if you don't have a public liability insurance in place. If you have an insurance for your property, but to have the AL, you need a public liability insurance. We have our colleagues over there from All Insurance that can check if you have the public liability insurance, and where you can check the terms and see if they can offer a more competitive rate. But this is something that could lead you to lose the license. If it's in a villa, not a problem, because you could apply for a new license the next day. But if it's an apartment, you can't, because the apartments, the AL licenses are only available after the 6th of October, only on the inland territories, or if it's your main residency and you rent for less than 120 days, okay? So I said that this is all bad news so far, and it gets worse, okay? No, they don't check, because the only thing is the lady was asking how they can check if you have a public liability insurance. What I'm saying is that they don't check. It's if you have an audit, because at the moment, if ASAI or the local parish, they are giving more powers to the local parishes to audit ALs. So if they find out that you don't meet the criteria on an AL, it's not only the public liability insurance. You need to have fire extinguishers. You need to have a sign saying that you abide the noise law. There are a few regulations that are related with the AL. I'm just giving you an example of the public liability insurance, but there are others. If the ASAI goes there and you don't have the fire extinguishers, they might notify you to say that that's one of the causes for you to lose the license, because you're not fulfilling all the regulations. So they're not asking for any of these, but it's when you, if you have an inspection or an audit, that could be an issue, okay?
One more question. The first one is unanimous, second
Yeah.
one 2/3, and the third condition is votes?
I think it's 2/3 of the votes as well. I'm not sure. To be honest, I haven't checked, but I think it's 2/3 of the votes, okay? We need to check that, Fernando. The 30%, if it's 2/3, or if it's, we can check and then give the answer later.
Ricardo, I'm not familiar with the maximum of 120 days rental. What is the difference between a regular AL license and a maximum of renting out 120 days?
I mean, what the government is saying is that the new CEAL tax and these new restrictions don't apply if you live on the property the whole year and you just rent the property or part of the property up to 120 days. We don't know how they will control this, but they can, because they can see the invoices. But the definition is that when you have the AL license, when you get the AL license, you get like a villa, apartment, you can get an hostel, or you can get what they call bedrooms. And bedrooms is when you live in the property. It could be an apartment or a villa, and you just rent bedrooms of your property. And because it's your main residence, you live there. So I could be living in my property and renting 1 or 2 bedrooms to tourists. I still live there, and as long as I do that for up to 120 days, I'm exempt from these restrictions. Yeah, but it's only if it's an apartment, again, because villas, it would already be exempt for villas. It's the apartments. In those circumstances, if it's your tax residency and you only rent it for less than 120 days, and again, I don't know how they will control this, but they have the means, because you do the invoices. The invoices, you need to send them to the tax authorities every month. So if they want, they can check that you are renting for more than 120 days, okay?
So Ricardo, does it also count for if you own the apartment, it's your primary residence, and you only rent it out for less than 120 days, the condominium cannot expel you from that apartment?
They cannot cancel your license, no.
Okay, well, but you can also apply for a license, even if the condominium does not like
Yes.
Okay.
The thing is that on the first, they put here that if it's a new license, it needs unanimous approval of the condominium for the use of the AL activity. So if you are trying to get the AL, we're going to say that it's your main residency. I'm unsure if they're going to ask for these minutes stating that in that condominium the AL it's allowed. We can check to see if it's possible. To be honest, I don't have that. I said that I might not have all the answers. Sorry, but we can check. If it's a new AL license, they live in that property. Do they need to, because they rent it for less than 120 days, will they need to have what is on number 1, where you need to have the unanimous acceptance from all the condominium? Or because it's only rented within your property for less than 120 days, whether it will be possible because of that. So we need to check that. Okay. Now, council tax will increase. I mean, council tax in Portugal is very low, but it will increase for everyone that has a rental license, okay? So when we calculate the council tax is the IMI that you normally pay in May. If you pay in installments, you will pay in August and you will pay in November. Normally, I have an example here, if you have a property which is 20 years old, it falls here, okay? 16 to 25 years old, you only pay 80% of the amount. You probably never noticed because you just received the tax bill and you never checked how they calculated that. So what they are saying is that if you have an AL, this coefficient doesn't apply. You will always pay the 1. So that means that if your property is 20 years old and you were paying 80% and 80% was 400 euros, it means that in 2024, which is the tax, the council tax, it will be 500 euros because it increases the coefficient from 80 to 1. It's not a lot, but it's another thing, another tax, another thing that you will have to calculate when you determine your night rates. You will have to consider that you're going to pay slightly more council tax on top of everything else that you already paid. So it's another extra, okay? So now this is the problem. The CEAL tax, okay? The CEAL tax, CEAL, it's Contribuição Extraordinária Alojamento Local, so local lodging extraordinary contribution. The government saying that the CEAL is going to be used to fund public housing. So they will use this money to build more houses, social houses, etc. I hope so. The problem with the CEAL tax is that we already know the formula. We already know how it's calculated. It's based on 2 coefficients, which relates to the tourism and with the urban pressure in each municipality. The problem is that no one yet published those coefficients. So we can only guess how much is going to be the CEAL tax, but we don't know for sure. Anyone that has a rental license in place, which is an apartment, so again, the exceptions are the ones that are not in inland areas. So anyone in Castro Marim doesn't pay CEAL, okay? In Tavira, if you have an apartment, you pay CEAL. If you don't have an apartment, you don't pay CEAL, if it's a villa. But if you have an apartment and you live and it's your tax residency, you also don't pay the CEAL, okay? The CEAL, it's applicable to all establishments in the form of apartments and properties integrated in autonomous buildings throughout Portugal, except Madeira, Açores, and the inland territories. The inland territories were the ones that we were checking before. So, Cachopo in Tavira, Santa Catarina de Fonte do Bispo, Castro Marim, I don't know all of them, Vila do Bispo, and so on. We have here a guess. I mean, we spoke with people that said that is 17 euros. We spoke with people that said that is 40 euros. If it's 30 euros per square meter, and this is a guess, it means that if you have an apartment with 80 square meters, that you don't rent, but you just, I mean, you rent some from time to time, you use it. Irrespective of how much income you're going to make, you're going to pay 2,400 euros on this tax. I spoke with a client the other day. He's American. He has an apartment that he never rented. He got the rental license because he thought that maybe in the future he will rent. He lives still in the US. He comes here sometimes. Sometimes it is friends and family. He was saying, if it's 1,000 euros, 1,500, I might pay just to continue with the AL because then I cannot get an AL in the future. But if it's 3,000 euros, maybe I'm just wasting my time and my money and I would just cancel. You can see the problem that this will create because the government, what they are trying to say is, okay, you stop with your AL and you put your property to long-term lets. And there will be more properties available to long-term lets. The price of the rents will go down. And the people, the Portuguese, the locals, will be able to afford the rents. The problem is, I mean, in our situation, we know a lot of clients that are in the UK, in the US, in Ireland. They own a property here. They bought it because they like the place and they want to make their holidays here. And then they saw Airbnb booking and they just said, okay, let's just do some rentals, get the rental license because it helps us funding the apartment. But now, if the CEAL, which we don't know how much is going to be, okay, yet, if the CEAL is too expensive, they will just say, okay, we're going to stop the AL and we either do something else, which we can talk about it later, or I'll just stop the AL period and there's one less property in the market. So the pressure, the urban pressure is even higher because tourism is rising. Every year we know that there's more tourists coming to Portugal. Since 2014, the tourism has been booming in Portugal. I mean, the airport just announced the other day that there's 4 new flights directly every week to Faro to New York. There was none. So there's more people coming. There's more people coming from the US, from Canada, from all other countries that were not used to travel to Portugal. And if you stop the AL, there will be one less property to rent to those tourists. So the pressure will be higher because the incentive for you to move to the long-term lets, we can talk about that later. Perhaps it's not possible because if you rent it to long-term or if these clients rent it to long-term, that means that I cannot be on holiday on my property because I bought this property for myself and I'm just renting it some of the months to help me pay the mortgage. But if I have to pay a lot of taxes, I have 2 options. I either stop the AL and just use it myself, or I have to increase the price by night to factor for those 2 or whatever 1,000 euros that I pay every year. But the guess at the moment, we spoke with other accountants, with people from the Association of Local Lodging. The guess, I think that 30 euros won't be much far from the truth. I was hoping that would be half of these, but I don't think that that it will be as low. The only question that we have at the moment is, because it hasn't been published, the law has been published, but the CEAL needs still to be published. There are the coefficients need to be published. We pray that because the Prime Minister resigned, that if they dismiss the Parliament immediately and not wait for the end of the month, that these coefficients will not come to the light this year. But if your rental licenses, your rental activity is active on the 31st of December, that CEAL tax is going to be due by June next year. So even if the license is owned by the rental agent, because sometimes we have the situation where I own the property and the rental agent owns the license. he will pay, but obviously he will have to charge me because it's, and if he doesn't pay, the debt goes, sorry, the debt comes to me. So it's a critical situation here. Okay, and I'm afraid that we don't have many answers because nobody knows how much is going to be the coefficients. We only know that it's related to tourism in the area where your house is, your property, and relates to the urban pressure on that council. But everywhere on the press, etc., the amounts vary from 17 euros to 40, 50 euros and more. They say that because the tourism is increasing, they say that in the following years, the CEAL could be higher as well. So. That applies to every apartment. It doesn't apply, it doesn't matter if you are resident or non-resident. It applies to apartments, with the exception the apartments if you are a resident in that apartment, or exception of the apartments that are not in the inland area. So if it's in Castro Marim, it's not a problem. If it's in Cachopo, it's not a problem. Okay? Sorry.
What about the moradias?
Moradias, it's not a problem. Moradias, villas, it's an independent unit, houses, they will not pay the CEAL.
Not independent property. So only the properties that on their registration only have a number without letter after, without no fractions, is considered independent. Everything that has villas, as Ricardo told, the link villas, and they have the same article and different letters, they are considered as apartments, not individual properties.
Yeah, we need to check on the caderneta predial, which is a tax register. So, for instance, I think in Cabanas, I think Upumar has villas, right? And they are linked villas.
In Upumar exists that situation,
It's
yes.
linked villas because the article is 1035, for instance, fraction A, fraction B, fraction C. And it's a villa, but it's a linked villa. So it's the same as an apartment. The only ones that don't pay the CEAL, it's when there is independent villas or houses, and it states on the tax register units for independent use, okay? And again, the ones that are in inland areas, Castro Marim, Cachopo, etc., they don't pay, even if they are apartments.
He mentions on the habitation license. One thing is total ownership, and another thing is horizontal ownership.
Exactly.
Everything that is horizontal ownership on the certidão predial is considered a not independent property, so it's considered as an apartment.
The same as an apartment, yeah. In terms of one of the changes on the local lodging, what they are trying to offer to owners that have apartments is stop the AL, rent it long term, and you pay 0 income tax on your property. So I have an apartment in Tavira. I operate as an AL. I don't live there, and I not even go there on holiday. So I use that just for AL. I rent it the whole year. I'm going to pay the CEAL, and I think it's going to be expensive. The government is saying, okay, one of the options is if you stop the AL license and rent it long term. The long term needs to be for at least 1 year. Okay, so it's not for medium term contracts. I need to rent it for long term. If I do that, I don't pay the CEAL and I don't pay the tax. But this means that if I do that, I would have to have the license already since 31st December 2022. So it's not for new, it's for the ones that been in the market before. And I need to stop the license. And if I stop the license and then I change my mind, I cannot go back because I need to wait until 2030 because I cannot get an AL license on my apartment in Tavira. So it's a decision that will save me some tax if I can get a good rent it may be attractive, but if I rent my, let's say, a 2-bedroom for maximum 1,000 euros a month, perhaps I won't get that much. I might get 800 euros. 800 euros times 12, I could do that easily in the summer just for 1 week, 800 euros or more. So it's, again, a financial exercise that we need to do to see what is more attractive. Also because there are other alternatives. We could do medium-term contracts to avoid the CEAL, but in those cases, if it's medium-term, you pay the tax. You pay the residential long-term lets because they only offer the possibility of you to pay no tax if you do switch from touristic lettings to long-term lets. And you can do that next year. You don't need to decide now. What I say to all the clients is, this is a lot of information. Don't make decisions yet because we don't know how much is the CEAL. We just need to be aware of all these and be prepared, start to plan, because anyone stopping the license now, they might not be able to get it within the next 5 years. And we don't know how much is the CEAL. And hopefully the CEAL will be released in December. So we still have some time to decide what we want to do. And we just need to make sure that we are aware of all these because these will have impact on the markets.
You need condominium approval for these long-term arrangements?
No. The long-term lets, you have no business activity, no VAT, no extra payment to the water company. You don't have any of that. So if I want to let my property, I could do it to anyone with or without license from the condominium.
So Ricardo, just to be clear then, I've got a client who's got his short-term rental license and has maintained that just for security, just in case, but for 4 years has had a long-term client. Mm-hmm. So should he still register, just to be sure? But yet, if he continues with the long-term tenant, because he's registered, will he still be subject to the CEAL tax?
He's registered, so he pays the CEAL tax. So he has an apartment, so he would have to stop the rental license. And for him to benefit from the 0% tax on the personal income tax, I think that it has to be a new contract, because if he already has the contract in place, he's not really switching. So he would have to stop the AL and then find another tenant and do another contract, because it needs to be a new contract for the government to offer the tax. And the tax we're talking about used to be 28%, is now 25% on the rentals. So basically that's what they are offering you, that you don't pay personal income tax on that rental if you rent it between now and the end of 2029. You need to make that decision. So I could have a rental license and I want to keep, and I might just want to do the contract. I might want to decide to do the contract next year. And as long as I do the contract with these tenants before the end of next year, I will still benefit from the exemption. One of the things that I was speaking with a client on when we had the break, the coffee break, you need to plan if you are thinking of selling your property or stopping the rental activity. There are, or there may be consequences when you do that. So some of the simulations I've done in terms of the capital gains are a bit scary, but there may be situations that could be avoided. But what we need to do is to do some planning, and you need to be aware of the consequences and how the capital gains are assessed to avoid making the mistake. Because what happens to us sometimes is that people get into our office and said, oh, I just sold my property in March. I know that I need to do the tax return now. And then it might be too late for us to do anything. We were speaking on a case that we had this week from a client of ours. She sold the two apartments that she had in local lodging in the center of Tavira because the property prices are very high. And the capital gain tax, because it was sold as a business, was a lot more expensive than if it was not. But because she started the activity a few years ago, we made the alteration to the tax return in 2021. So we did it now, but retrospectively. And that way she's going to pay a lot less capital gain. So what we need is to have the time to plan and see what are the consequences. The same situation is when you have, if some of you have local lodging activity and you pay VAT, so not VAT exempt, one of the consequences of stopping the AL, and they are saying, okay, stop and rent long term, but if you stop and if you have VAT, you may have to pay some of that VAT back. So we need to make that calculation, because if for instance, you've done works on your property and you pay 0% VAT because you are on the VAT regime. So I know that most of you are not on the VAT regime, but there is people that are on the VAT regime. And when I do some civil construction works in your property, the VAT that you pay is 0. So it's good because you save 23% on the VAT. But then if you stop your activity, because you were supposed to keep the property for 20 years, you're going to have to pay some of that VAT back. And all those things need to be considered before you make a decision of stopping the AL or not stopping the AL, selling the property, not selling. So all that needs to be balanced. And that's why I say don't rush into decisions. Listen, see what are the options, and then decide. Because if we rush into a decision, we may be making a mistake or falling in the trap that they want us to do, which is stop the AL and then we cannot do short-term rentals. So just try to not panic. So residential rental taxes. So again, this is another change that the government has done. They reduce slightly the rental taxes. So if you rent, when you rent long-term or medium-term, you used to pay 28%, and now you pay 25%. Also, because if you are already renting your property long-term, the government didn't allow you to increase the rentals. So the rentals, the inflation, I don't know, was 6 point something %. So you should be able to increase the rent by 6 or 7%. But what the government said was, no, you can only increase for 2%. So what they do is, in those circumstances, they give you a discount of 10%. So if you are taking a rent of €1,000 a month, they say only 900 are taxed, and the tax is 25%, used to be 28. So there is a small incentive to those that are on the long term. I'll show you on the next slides how is the tax calculated for those that don't know or don't remember. So not on the next slide. I'll get back to that one. Okay. So at the moment, if you have AL rental income, and let's say €10,000, 3,500, it's the taxable income. If you are a non-resident, you pay a fixed rate of 25%. So it means that you pay €875 for each €10,000 of rentals. You are effectively paying 8.75%. Okay? This is different if you are on a containment area. I have a client here that is in Lisbon, and he doesn't pay over 35%. He pays over 50%. Okay? What the government says is that the profit that you have on your AL is 35%. That's why it's so attractive for many. The tax is 25% if you are non-resident, but if you are resident, the tax can be higher or lower depending on your income. So if you're earning a lot of money, you have pensions, you have all that's going to be considered when you do the tax return if you are resident. And in that case, you don't pay 25, you might pay 37 or more, which means that you, at the effective rate, might not be 8.75, might be 14%. When we compare with the long term, the example, on the same 10,000 euros, you can deduct expenses, so there is no coefficient. They just say you need to show us your expenses. And then on the net income, you pay 25% rates. The expenses allowed are normally the council tax, the stamp duty on the registration of the contracts, the accountant, utilities, the property insurance, condominium fees, property refurbishments. If you pay a commission to a state agent, or if you pay something that is on the contract that you need to have that rental, you can also deduct that. But effectively, even with all those expenses on that example, you are still paying 18.75% on the gross income, which is more than the double that you pay on the short term, okay? But in this example, there is no fees for booking or anything else if you do a long term, because normally you have the same tenants all the year. So just going back to the other slides where I was. So on the residential rental taxes, one of the changes is the limits on rental increases. So you cannot rent for more, you not increase the rent for more than 2% of the last rent charge in the same property in the previous 5 years. I call your attention to this because this is very important. If I buy a property now in Tavira, this is crazy, okay? I buy a property now in Tavira, and that property, I not even knew that the property was rented. But the owner rented it 4 years ago to a student, and that student was paying 500 euros. It was before me, I just bought it now. But if it was rented in the last 5 years, and I'm now renting it to my colleague, I can only increase the rent by 2%. And I not even knew that that property was rented. And if I go to the tax office, they might not give me that information because it's not my property. They might not give me the information. But, and I don't know how this is going to be controlled, that means that if I bought the apartment, I was thinking that I was going to rent it long-term for 1,000 euros a month, but the previous owner had a rental contract 4 years ago, which it was 500. And by law, the government can stop me for renting for more than 500 plus 2%. So this is, again, one of the alterations. I mean, it's not so relevant, but when you are in a specific area and if you rent for a lower amount than the council determines, you will also have an additional 5% reduction on the rents. And those, so that's the 5% here. It applies when you rent for a price that is lower than what the council has determined. I can tell you that the council has determined very low amounts, so very few people will want to choose that regime. Here, the 90% coefficient here, that is if someone, let's say I had an apartment in Tavira that was rented for the last 3 years, and this year I increased, by law, I can increase 2%. So what the government gives me is that I only pay tax on 90% of that income because it's a way of them benefiting me because they limit my increase. I should increase by 6% because it was inflation, but by law, I can only increase by 2%. So the government says, we give you 10% of that income tax-free. So I only pay rent tax on 90%. So effectively, I'll be paying 22.5. So these are, like I was saying, these are the comparison between the local lodging and the long-term lets. For a long-term let, basically, people ask this question many times. It's an habitation, it's a residential let. We have different concepts. So if I want to stop the AL and benefit from the full exemption on the tax, I need to do a residential contract, and that needs to be a minimum of 1 year. And if I do that, I don't pay any tax. However, I don't want to do that because I still want to have access to the property. So what I can do is I can stop my license. I rent it. Airbnb nowadays allows me to do listings up to 1 year. I rent it through Airbnb for touristic purposes, not through AL. But that means that I need to rent through this system, which is what we call category F. And that means that I will pay more tax. There will be no CEAL, etc. But I will pay more tax. I need to understand that it's a totally different process. It's not the government doesn't assess 35% of my income. No, that's gone. What they do is, okay, I'm going to tax you on your rental income minus the expenses, and we need to have evidence of those expenses. The expenses that are normally allowed are these. This also means that every time that I have a contract, and the contract can be verbal, I need to register it at the tax portal, and I pay 10%. So this example, let's say I stop my AL license, and now I'm going to rent to, there's people that comes here for 3 months in the winter. There's people that sometimes want my property for 1 or 2 weeks. I said 3 months initially. So when I do those rental contracts, every time I register, I pay 10% stamp duty. That is later deducted from the property tax that I'm going to pay, okay? So it's part of the expenses. But 10% stamp duty, it means that I rent the apartment for 3 months for €1,000 a month. I pay 10% of 1 month, so I pay €100. Those €100 will be one of the expenses that are deducted when I assess the personal income tax. But if I rent it just for 2 weeks for €1,000, I also pay 10% of the 2 weeks. It's 10% of 1,000 because it's either 1 month's rent or whatever is the rent if the period is less than one month. So this could be an alternative to the local lodging. So renting to tourists through rental properties with transitory rental contracts. I mean, I'm not a lawyer. I don't think there's a lawyer in the room, but we discussed with our lawyer and with other lawyers from the Association of Local Lodging. There is a possibility, and that's why, because all of this is changing, the portals are also not stupid. They don't want to lose business. I mean, this happened in New York, and it was a big loss for Airbnb because a lot of people took those properties out of Airbnb and put on pirate portals to avoid the taxation and the rules in the US. And they know that. So Airbnb, for instance, they now allow you, I'm not an Airbnb client, but I think they now allow you to longer contracts. It used to be just a few nights or weeks, and now you can have longer stays. It could be up to 1 year. When you do that, if you don't have a AL license number, normally you say, oh, I cannot register. So I go to Airbnb, I want to put my property there, and it asks for the AL license number. If I stop my AL license, I don't have a license, but I can still rent my property. Nothing stops me from renting my property as long as I say it's for transitory reasons. So I could rent it to Liliane because she's studying now and in Tavira, and she needs to rent my property for 3 months or 2 months. Or I can rent it to someone that came to spend some time in Tavira as a tourist. So the transitory period allows you to rent it for periods shorter than 1 year and still consider it residential. So the big advantages of this is that because you stop your AL, there's no CEAL. There's no VAT limits because there's no activity, so there's no threshold for the VAT. The domestic tariff that you pay to your water company is the normal because you don't pay commercial tariff because you stop the AL. And when you sell, you pay the normal CGT. The issues that I see on this solution are eventually, I mean, I'm not a lawyer, but I think that one issue could be the eviction process. And the other is obviously you pay more tax. You pay, instead of 8.75 on that example, we were paying 18.75. The eviction process, I mean, I don't know. At the moment, if you have someone that goes to your AL, your apartment, I book through booking.com or Airbnb. If he doesn't check out on the day that was agreed, I don't know if you ever had a situation like this. I don't think it ever happened, but I would imagine that I would just I would just ring the police and I'd tell them that they need to leave, right? Because they booked for a service, and that was a service that was for X amount of days, and you can kick them out because that was what was signed on the contract with Airbnb. If it's no longer an hospitality service, but if it's a rental, if someone comes through Airbnb, normally, I would imagine it's a tourist, so it will be the same situation. But if they have bad intentions, and if they, after the checkout date, which was 1 month, they don't want to leave, and if you call the police might say, it's not my problem, you need to go through court because this was a rental, not a hospitality service. So it could be an issue, I think, to do it like this. Not that I think that people that go to Airbnb have that intention, but you don't know what's going to be in the future. If people when they find out about these laws and about these things, in Spain, for instance, there was a big problem. I think it still exists with properties that were vacant, and people were occupying those properties. And the government, they're on the law, they know that they cannot be evicted because of the age or because of the family, or it's a big problem. And you just have a property on the hills that you thought that was closed, that you use for holidays. So what I'm trying to say is that people, if they are mean, they can find the solution for their problem, and then it creates you a problem. So I don't know. It's something that I don't think it ever happens. I'm not trying to say it will happen, but it's something that concerns me.
Ricardo, what about companies or owners that don't use Airbnb, for example, that have their own homepage and advertise the short-term rentals there with the IL number? As far as I know, it's law to have the number to be able to advertise.
No, you can still rent. You can advertise. What they say is that for you to advertise for short-term lets, you need to have an AL license, okay? What this is saying is that you're not renting for, you're renting not for short-term for tourists. You are renting, it's not a service that you are providing, it's not an hospitality service, it's a rental. You are renting your property. So if I own the property, I can do whatever I want with it. I could rent it to Sarah for 1 year, or I could rent it to Liliane for 1 week, or I could just let Fernando live there for free if I wanted. So I decide, because it's my property, I own it. So if I'm advertising on my portal, I need to say it's not AL, it's I'm renting the property for transitory period. So I rent the property, and it means transitory because I cannot say residential, because if I'm renting for residential, it's 1 year minimum. They don't allow contracts that are for residential for less than 1 year. But if it's a transitionary reason, I could rent it. I mean, Liliane wanted to come to Tavira because she was finishing her studies and she wanted the property there for 6 months. So I rented to her. Sarah wanted to come for 2 weeks because she's seeing some family and she needed to rent it for 2 weeks. I can still rent it. I declare the income not as a business, but as a rental income, which is category F. I pay more tax, and the only way I can advertise this is if I say it's transitionary reasons. In terms of the tax, it's simple. In terms of the regulations, that ASAI, etc., I mean, If I have my apartment in a condominium, they stop my license because they say it's not possible to have AL anymore in that block of apartments. Nothing stops me to rent it transitionary to for small periods because I'm renting it. It's my property. It's category F. It's a rental. It's not a business that I'm providing.
So I have a question. How is the 2 weeks transitionary different for somebody that would come on a holiday for 2 weeks? I mean, they can also say, I'm just going on a holiday for 2 weeks. Like, how can you even know when you rent out what is the intention of the people visiting? It seems very difficult.
You don't know. You don't know. What I'm saying, and I'm not a lawyer, is that I think that you are not so much protected if it's a residential, if it's a contract, rental contract, than if it's a service. If I'm providing a service, if I have a restaurant and someone is causing me a problem, I call the police. If I have an AL, it's a service, someone is not checking out or is destroying my property, I call the police and then he goes because there is a service that I'm providing. If the person comes through Airbnb, but it's a different nature, so it's a rental contract. If it's a rental contract, if I call the police, I think that they might say, it's not my problem, you need to do an eviction process, and that goes through courts. But I'm not a lawyer, so we should have one here for next time.
Yeah, just building on that, what happens if you rent out your property through different means like advertisement in your home country? So you set up a sort of agreement in your home country and they come here and they use your apartment and they leave. Are the rules then different from what they are now?
No, the rules say that if you rent a property in Portugal, the property is considered a permanent establishment, and that means that the rental is always paid in Portugal. Okay, either a rental or a business income. It needs to be reported here. It doesn't matter where is the owner lives, if he's tax resident or not, if it's a company or not. It doesn't matter. It needs to be paid, the income, the tax needs to be paid here. We have people, I mean, just the other day I was speaking with a client, he's in Austria. His son has a lot of Airbnbs in Austria, and he just bought a property in Tavira. And he was saying that he can do the advertisement in Austria and get the clients here. That's fine. But even if they pay through their website in Austria, that income needs to be reported here because it refers to a stay in Portugal. So if you buy a night in this hotel and you pay on their website in Belgium, they still need to report that income, and the invoice needs to be paid, the tax here, because it's done through a permanent establishment. The establishment is the building, the premises. Either it's an hotel or a house or an apartment, is the same. So, but this means that this could be a solution for some, but it means a lot more work, because it means that every time that if you have a guest for 3 months, we need to register their contract on the portal, and the contract could be valid, could be verbal, could be just some papers that you have and that they need to sign. It's much more complex to do it that way, because normally when you register a contract on the tax portal, you do it for long term, for 1 year or more. But it's possible to do it for 3 months. There's people doing it. They are doing winter lets a lot. It happens a lot in Tavira. I use the property with my family in the summer, or I use it not on the hotter months, and then on the hotter months I rent it to for tourists. But there is also the opposite, where I use it on the hotter months with my family, and during the winter I have some Swedish or some people that come from colder countries here to benefit from the warmth. The rules about the new reinvestment regime. If at the moment, if I have an apartment in Tavira where I live, and I sell and I buy a villa, so I upgrade it, I reinvested the proceedings of my sale, and I don't pay any taxes. Now they are saying you need to live 2 years in that apartment to be able to reinvest. needs to be your main residency for 2 years, and you cannot have done this in the last 3. So I'll give you an example. We had a client from the UK that she bought a house here a few years ago when she was not resident. And then she started dealing with the visa to come and live in Portugal this year. In the same time, she thought, I'm going to sell this house, I don't like it so much, and I'm going to buy another apartment, which she did. Up until the 6th of October, we would just go to the tax office, change the address. She sells because it's her main residency, because at the time she sells, it's the main residence. She does the reinvestment in the other apartment. She doesn't pay any capital gains because she invests more than the sale. Now, that's no longer possible because we're going to change her address. I think we did it in October, and she's going to sell now. She would have to wait 2 years for that to be her house and then sell. Okay? So the only exception, you need to have a very good reason to have an exception to this. So if you were living in the property for less than 2 years and you want to benefit from this exclusion, you could say, I mean, I got divorced, so it needs to be a strong reason for you to for them to allow that you benefit from the reinvestment within less than 2 years. Okay, so you need to live in the property 2 years, and then the reinvestment will be accepted. Otherwise, they don't. The reinvestment, as some of you may know, you have 3 years to reinvest after the sale or 2 years before. So that means that if I've been living in that apartment for 2 years, I sell, I have 3 years to reinvest into another property, or I could have bought already the property up to 2 years before I move. Okay, so I have an apartment, been living there. Suddenly I buy another house which I want to move there. When I sell the apartment that I am in, as long as it's within 2 years, I could do the reinvestment. The reinvestment could be before or after the sale, okay? Okay, this is the mortgage repayment that I was talking about. Because the interest rates have increased considerably, the government now allows that you can use the mortgage repayments as to avoid paying the capital gains. And this could be not only on the main house, because on the main house already existed, but also on the secondary house. And it's retrospectively. So anyone that sold a property in 2022 or 2023, it can benefit from this. So let's say I sold my property last year, 2022. At the time, this law was not in effect. But I can say now to the government, okay, I'm going to use, I already paid the capital gain tax, okay? So it was 2022, I sold my apartment, I paid the capital gain tax already. But with this law, the government is saying, if you use the sale of that house that you already sold and pay the mortgage on your main habitation or on your children's main habitation, if you pay their mortgage or your mortgage, you can benefit from the exclusion. So if anyone would consider doing that, they have 3 months to do it after the 6th of October, okay? In the future, anyone doing this until, I think it's the end of 2024, you are able to sell your apartment, so your secondary habitation, and you will deduct the mortgage on that apartment. If there is no mortgage, you can take that money within 3 months, pay the mortgage for your son main habitation, or for yourself main habitation. This will only work if it's in Portugal and if the mortgage was taken for purchasing the property, okay? And it's a mortgage that already existed. It can't be just a new mortgage that you're going to set up now, okay? So we have these examples. That's where it gets the worst part. I would just skip this, but so sale price, 300,000 euros. This is for you to know how normally it's taxed, okay? So sale price, 2023, 300,000. In 2015, you bought for 175. There is a price coefficient. So normally the government allows the price to be increased. This is the index that was released this year, just last week. So if you bought in 2015, the inflation they consider is 12%. So the property is worth 196, and your gain is 104,000. Okay, 300 minus 196, 104. You paid taxes on the purchase, IMT, stamp duty. You have some invoices that you pay the builder to paint the house and to refurbish. And you pay to the agent 15,000 on the sale. So you have 35,000 euros. It's important that you realize that the invoices, every time you have a property, we need to have a copy of the invoice to be able to use it. And the invoice needs to have your fiscal number. It needs to have the address of the property. Otherwise, the tax authorities will not accept it. Some people ask, what about the lawyer's fees? If the lawyer's fees say legal fees for acquisition of property in so-and-so, we can use it. But in most cases, the lawyer just writes legal services. The tax authorities will not accept it. Even our fees to deal with the tax return can be used if we say there, tax return for the sale of the property. So in this case, there was 35,000 euros of expenses, 104,000 was the gain, 69 is the net gain. The Portuguese tax authorities tax half, and for 34,500, the average rate is 28%, so you pay 9,698. This is the same for residents and non-residents, okay? Before, up until the end of 2022, the non-residents would pay 28% of these amounts, okay? Which was more than this. So 28% of 69,000 was always more than the new rules. The new rules, because it's only on half, even if you pay the highest rate, which is 48, you are effectively paying 24, which is less than 28 that you used to pay. So residents and non-residents now, they pay the same, okay? So in this case, on this simulation, the tax was 9,698. What happens next? The same example, but you have a mortgage. So the mortgage on that apartment that you just sold was 50,000 euros. Very important. People make these mistakes sometimes. Okay, I'm going to put my property on the market. I'm going to pay the mortgage and put it on the market. Or I just pay the mortgage on my property now for some reason. We can only consider the mortgage that was due on the deed date, okay? So sometimes we had clients that said, oh, I had a mortgage of 200,000, I just paid it last year. I'm sorry, we can only use as a reinvestment the amount of mortgage that was due at the time of the sale. So the same exercise here, and before we said that we were paying 9,000 euros of tax. In this case, we are paying less because we used 50,000 euros of the 300 to pay the mortgage, which means that we use 16.67% of the proceedings to pay the mortgage. And when we take that out of the taxable gain, instead of 34,500, the new gain is now 28,750, which means that now the tax is no longer 9,000, it's 7,500, okay? So the mortgage repayment is available even on this property, which is a second property. And this is a new law, okay? It was not possible until the 6th of October. But it's even more attractive if you are selling and you use not only the 50,000, but you actually took the 150,000 and paid your main habitation. So I've paid 50,000 euros on my apartment because there was a mortgage when I sold it, and I paid 50,000. And then with the money that was left, I took 150,000 and I paid the mortgage on my house, my main habitation. So I can use both amounts. And in that case, my reinvestment out of 300,000 is 2/3. I use 2/3 of the amount, which means that now my CGT, it's only 1/3 of the 34,500. And then the tax rate is also lower. So I'm going to pay 2,000 euros. The principle of the reinvestment It's the same as the mortgage repayment. So if I reinvest 300,000 when I sell my property, I pay nothing. But that's only available for main residency, okay? The reinvestment, it's only for main residency. Mortgage is for both main and secondary habitation. But the reinvestment, the principle is I need to reinvest the proceedings of the sale. So here, if there was a main habitation and I reinvested 300,000, the tax is zero, okay? The tax is zero because I'm reinvesting the proceedings. But if I'm only reinvesting 150,000 or 200, like here, I'm reinvesting only 2/3. So I have a reduction of 2/3 of the taxable amounts. Okay, now the worst part. When you have an AL and you are selling. So this property was an AL.
Time to
This no, this already started. This is effective as of 6th of October 2023. So this is effective as of 6th of October 2023. The next slide, it relates when you have the property with AL, okay? When you have a property with AL, it considers that it's not on your personal sphere, it's a business. And the taxation, where here, it's the taxable gain is 50%. What happens with the property that's in AL, because it's a business, the taxable gain is not 50%, it's 95%. Okay? And this is something, if the business started after 2021, it's 95% period. So there's no other way. So if the property started the business after 2021, it will always be 95% of the taxable gain.
I always understood that if you sell your house, the AL is not transferable.
It's not transferable. No, the AL, it's not transferable. But what happens is that when you sell a house that is on AL, you are actually making a profit, a gain on your business. It's not on your personal sphere, it's a business because the property is part of the business. It's all in your name and you are a sole trader. It's a business, okay? So you transfer the property from the personal sphere to the business. So when you sell it, you pay more tax. If you started the business before 2021, we can opt by the old regime and see if it's more beneficial because the new regime came into force in 2021. Under the old regime, when you stop the AL, eventually there was you could be liable for capital gains just for stopping the AL. And with the new regime, that's no longer a problem. So if you stop the AL, you don't pay more tax. But what they say is that you need to wait 3 years to sell, because if you don't wait 3 years, then the taxable is not over 50%, but it's over 95%, which is the next slides.
And if you stop the AL now, how long have you got with your property before you have to pay capital gains?
To be here on this case,
but without AL, if we give up AL.
Yeah, if you give up the AL and stop the license, stop the activity, you need to wait 36 months to sell.
Oh, just 3 years.
3 years.
Okay. Thank you.
You could do during that period. You could rent long term. Okay, you cannot rent business. I'm sorry, guys. There was a retail agent over there just making a. I don't mean to.
So if you decide to sell regardless the 95%, can you then use the full amount for
payment to mortgage?
No reinvestment?
No. Because the property is not your the reinvestment is only allowed when it's your main residency. And if you are doing an AL, it's not your main residency, it's a business.
But it's
if I'm renting it through AL, it's obviously that it's not my main habitation. Even if my tax address is there, I'm limited. Only if I'm just renting parts of the property and up to 120 days per year.
But officially, it's my residency address.
Okay, officially, we're going to say that it's your main residency and we're going to use the reinvestments. There is a tax audit. They always do a tax audit on when there is a property transaction. And what do you think? We don't think that they will notice that, because what happens is every time there is a property transaction, when you do the tax return, we need copies of the deeds of everything, and they need to see that always. Even if there is no gain, they want to see it. The other day, Laura, that just gave you the microphone, she was showing me an example of a property in Quinta do Lago that it was sold. The real estate commission, the invoice, everything was correct. It was done by an agent, and on the deeds, it was referring to one agent, but perhaps they split the listing or whatever, and the invoice came from another. The tax authorities are saying that we cannot use that invoice, which was legitimately paid by the owner, because it's not the same that is mentioned on the deeds of sale. So they check these things. So if we say that it's your main habitation and you use for the reinvestment, the consequences could be that when it's the tax audit, they can say, oh, this was not your main habitation because you were making all this money from rentals. And it's obviously that you were renting for more than 120 days a year. And if it's a business, it's not your main habitation. So I think that in that case, only if you wait 3 years.
So in principle, you're saying that an AL cannot be your main residence unless you rent some rooms.
For less than 120 days and only rooms.
Okay.
Yeah.
Thank you.
Gain for ordinary house. You showed it before.
This. Yeah, in this case, because there was a mortgage repayment, without mortgage repayments, in this scenario, he was effectively paying 28. But it depends, because this tax rate here, it's variable. So if you make a profit of 1 million euros, taxable is 500,000, and the tax is not going to be 28, it's going to be 48, because it's progressive tax rates. This is something that is new because it started in 2023, and it means that residents and non-residents pay the same, because what was happening before was non-residents were paying 28% on the whole amount, and they were being penalized, and the European Court said that the residents should have the same rights as non-residents because we are all on the EU. So, but this is something that, like I was saying, it's the taxable income is 50% on all these simulations, because this is a property that is not in AL. If the property is in AL, the scenario is much worse, because you pay tax on 95% of the taxable income. So same second habitation sold less than 3 years since stopping the AL. So the same, 300,000 euros minus 175. Your gain is supposed to be 104 because there is a price coefficient. However, on the AL, there's no coefficient, no expenses. So the gain is 300,000 minus 175, so it's 125. So the previous gain was 69,000 because one was 104 minus 35. In this case, no expenses because you are on the simplified regime. You are assessed just on the gain, so no deduction of expenses. That's a very good question. There's a very good question. We are waiting from confirmation from the tax authorities. They are supposed to do a press release about this law. In my opinion, I thought that they won't allow the mortgage. But we spoke with people on the tax office and with tax experts that work with us, and they say, yes, it's going to be possible to deduct the mortgage. I didn't put it here because I'm not 100% sure until I see the law. Okay, that's something that will be published by the tax authorities. The tax authorities, The law has been published, but the tax authorities now need to say, how is that going to happen? Because at the moment, there is not even tax forms that allow us to do this. So, okay? But that means that the gain is now 125 instead of 69. And because it's taxable at 95% of the 125, it's 118. And if you are a non-resident, it's a fixed rate of 25%, so you pay 29,000. If you are a resident, you would pay 49,000. And this is on a gain of effectively just 125. So it's a lot of money.
I just want to ask about the expenses in terms of the NIF number. If you got your main residence and a second residence, and the NIF is applicable to your first residence, what address do you put on that if the work is on, say, the second property?
So normally, we had situations where the builder issues the invoice to the NIF and puts the address of your first habitation because it's your tax address. They need to specify, if that's the case, they need to specify in the invoice works related to the house located in, which is the second one, right? So because otherwise, the tax authorities, when they do the tax audit, they're going to say, well, you can't use this invoice because it's not for that apartment, it's for the other house. And this is a problem because tax authorities, they are not easy on these things. They are very adamant. We had a situation last year where a client did some works in Olhão, in a property, and there was a considerable amount of invoices that were all legal, and the tax authorities didn't accept it because there was no project approved at the council. They say, oh, you did all those works, but you never did any projects. How did they found it? I don't know. Not even we knew. We told this to, we made a complaint to the tax authorities, obviously because it was a very big amount. They said that they didn't give us the reason, and they said, take us to court. We referred to a lawyer that works with us. They paid the tax bill, and then after 1 year, they got the refunds. And it was a huge refund. It was like 50,000 euros of tax or something. But they had to fight with the tax authorities to do that. In that case, because it was over 50,000 euros of tax, fine. I'm sure she was pleased to pay the lawyer. But if it's 2,000 or 3,000 euros, sometimes people just say, forget it. But we had a situation as well. When there are works, construction works, which they call empreitada, where you contract the builder to do the works, the quote needs to be signed. Last year, again, we were doing the capital gain tax of a villa where there was no contract. And the contract, the guy that did all the works already closed the company and didn't want to sign for us to be able to accept the costs. So what we did was we put all the costs, okay? We take them to the tax authorities, and then the tax authorities say, oh, these ones we need to see the contracts. We speak with the clients. Do you have a contract for this? No. We had people on the office ringing the owner of that company, trying to speak with the daughter, trying to convince him to sign for a document. I think he signed, right? Yeah, more or less. Was it sorted or not? Okay. Yeah, but we had to, and again, we had to try and persuade the family of the builder to sign. What I'm trying to say is that the tax authorities, they will try everything for you to pay more tax. So I'm sorry. But they won, right? Because in most cases, if you take them to court, you win. The finances, if you take them to court, most cases you win because they don't have the reason. But the problem is sometimes people just don't want to that hassle, and they don't want to spend. Sorry, I shouldn't use this word, trouble. I have clients there, so sorry.
Hi, Ricardo. Just going back to the reinvestment. Is the reinvestment only allowed within Portugal, or can you do the reinvestment in another EU country?
You can do the reinvestment in another EU country if it's your primary house, okay? We were talking about examples because this is a new law. We were talking about the reinvestment, the repayment of the mortgage, etc. If it's your main habitation, so you live in that property for over 2 years because the law changed, okay? So you need to live in that property for over 2 years. You can reinvest the proceedings of the sale anywhere in Europe, EU, or if you are at retirement age, you could also invest in a pension fund to avoid the taxation. So you could do, I could sell my property for 1 million, and I could put $500,000 on a new property in Ireland, and I need to move my address to that property, okay? I have 3 years to reinvest in the new property, and I have 6 months to put it on a pension fund. But because I'm not at, I'm too young to do that. So I would need to be 65 to be able to do that. So when you are 65, you can reinvest in both situations, the house anywhere in Europe and the pension plan anywhere in Europe.
Are these numbers valid if I sell my main habitation and have an AEL license on that? These numbers?
The numbers, when you have an AL license, it's only considered your main habitation and only taxed at 50% if you rent it as only the bedrooms and for less than 120 days. So you have an AL, but you also live there. So if you are only renting bedrooms and you rent for less than 120 days, we can sell it and say that it's your primary residence. In that case, you pay the tax that we put on the first slides, which is over 50%. And again, if it's your main residency, you can reinvest by another apartment in Portugal or in the EU, or a pension plan if you are over 65.
Ricardo, the pension fund, does that have to be in Portugal? Can it be in the EU? Can it be in the UK?
UK. No, it can't be UK, right? No, it needs to be EU. So
Can
it could be Malta. Could be Malta, Cyprus.
Can it be Guernsey? If you
no,
say
it's not
Malta,
EU.
no?
No, it's not EU.
No? Isle of Man?
It's not EU.
No? Okay, thank you.
So, but the reinvestment on a financial plan, that pension plan, it needs to be, the conditions are that you don't take more than 7.5% of the capital each year, and that you are more than 65 years of age. And you need to take some money out. So it's not, you cannot just put the money there and not take any money. You need to take some capital out every year. So that would be another seminar. We can talk about that, investments, etc. But there are some alternatives. What I'm trying to say here is, in this case, we said that at the beginning. Liliane had one client that sold 2 apartments in Tavira. And the tax liability was something, let's say, like this. Actually, it was more because her gain is really high. The property is valued a lot. And because they are on the AL, the situation was that she was going to pay, let's say, 50,000. In their case, because she had the activity for, I don't know, since 2015 or something, we are going to change the tax return for 2021, and we are going to say she wants to opt for a different regime, and she's going to save some taxes. So maybe she's going to pay half, or not half, but perhaps 60% of what she was going to pay initially, because she was going to pay 95% and she wouldn't be able to use the expenses or the coefficients. By changing the tax return for 2021, what we did was we said that in 2021 that she was using the old regime, old rules, and in 2022 we stopped the activity, we transferred the property from the business sphere to the personal sphere, and in 2023 she sold. So when she sells, it's already on the 50% because it's already on personal sphere. But this was possible because we did some retrospectively, and we've been working on this file. If the clients, what happens many cases, many times, unfortunately, is that the person comes to our office in March 2024 and saying, I sold the property last March 2023, I need to do the tax returns now, can you help me? And then it's too late to change 2021 or to stop the activity or anything like that. So what we say is, here, please talk to us before selling. Okay?
Thanks. Ricardo, just going to ask, with AL, what's the position of a property been inherited by your children?
Inheritance.
Yeah.
There's no inheritance tax in Portugal, okay? Nothing. There, in Portugal, the only thing that exists is stamp duty, okay? If you have a property with AL or without AL, the only thing that your inheritors will pay is 0.8% on the value of the property, and that's the tax value. It's the value on the IMI, so it's very low. So let's say that you bought an apartment for €500,000, and unfortunately you died. Your children, they're not going to pay 0.8% on €500,000. They're going to pay 0.8% on the amount that is on the tax register, and the tax register could say that the apartment is 200,000. So after that, they sell the apartment because they don't want to live here, and they're going to sell it for €500,000. They're going to have a gain because they sell it for €500,000, but they didn't bought it for €500,000. They inherit, and the tax value when they inherit was 200,000. So there is a capital gain there. Also, when they, if they are, I would imagine that they are tax residents in Ireland. So if there is capital gain tax in Ireland, when they inherit this property, they will have to declare it in Ireland and pay the tax there. In Portugal, they won't pay, irrespective if they are residents or not. But it's always the country where you are, where the inheritor is living. And the 0.8% stamp duty is only if it's a direct descendant. So my children, I have 4, they will pay 0.8%. They won't pay nothing because I will sell everything before I die. but they will pay 0.8%. But if I leave something for my sobrinha, how do you say sobrinha?
Niece.
My niece, she will pay 10% because she's not on direct line. So if she inherits a share of my property, or if I didn't have children and somebody else was inheriting, they would pay 10%. Okay? If it is bank accounts, money, it's no stamp duty. It's only on properties. Grandchildren, they are descendants, so they don't pay. My wife, she doesn't pay. But she's going to go first. We already discussed. No? Maybe not, no. Because she works too hard.
Ricardo, you mentioned the tax value of a property. I believe that's the figure that we see on our council bills, yep. Correct? The valor patrimonial, yes. Correct? You mentioned a figure, a hypothetical figure of 200,000 on the example you just gave. I have a property which has a tax value of 1,000, which is a joke, to be honest.
It's a very old house.
Is there any way that that can be, and okay, I'm thinking of leaving a house to my children. They would end up with a massive capital gains tax if they decided to sell the house in the future after my death. Is there any way that that tax value can be revalued? Or is it a static figure?
No, it can be revalued, but because it's a formula, if your square meterage didn't increase, if the property is the same, they won't make much change. The only thing that could do is if you rebuilt it or if you did refurbishment, if the tax authorities consider that, o índice de festutez, não é? Acho que é isso, which is the index that we saw before, perhaps they would increase that, so like they are doing now for the council tax. But in many cases, unless you have a property that you increase the area, that you build a pool, etc., the amount of the council tax remains the same. The solution. We did that for other clients before where you could gift that property to your children. And when you gift that property, you could say that this property is worth €500,000. Okay, the commercial value. I don't know if it's worth that much. But if you say that, they pay the stamp duty on 0.8% of €500,000. If your children sell it later and wait more than 2 years, the base value should be the tax of €500,000. However, that's not what the law says. Okay, the law says that if they are direct descendants and they are just paying 0.8%, that they should pay the tax on the tax value. Okay, so you say it's €500,000, they paid 0.8, but on the tax value it says 30,000. So the tax authorities on the law that say that even if they sell after 2 years, the base value it will be 30,000. The interesting thing is that we had the clients that we did this, and they sold 2 properties for many millions near Tavira. And before, he didn't sold, he gifted them to the children, and then the children waited 2-3 years to sell. At the time, we got a tax ruling from a lawyer in Lisbon and the tax ruling from one of the big fives, I think it was PwC, that said that he would be paying tax not on the amount that was on the stamp duty, but on the tax value. We did the tax return like we did to others based on the amount that they paid the stamp duty. I spoke with a local guy here on the tax department, and they said, no worries, that's how it is. The guys at PwC were wrong, they say. I don't know, because I think that PwC was actually right, but what happens in practical terms is that they only look at the stamp duty that you paid. So if you paid 0.8% and you declare that it was €500,000, it worked. And in that particular case, he sold in 2022, so if he doesn't have problems in the next 4 years, you'll be okay. But I spoke with, it's not the first time we do this, so okay. So when we spoke with the client had already done it. So it was not us suggesting him to do it. He done it with his lawyer in Almancil. And he became our client when he was on the process of selling. We did the tax simulations. He showed us the tax ruling that he had from the lawyer in Lisbon and from PwC. And it was clearly saying that because it is stamp duty at 0.8%, it doesn't worth to say that the property were worth 2 million because they would consider the tax value. However, because we had situations in the past where that was not the case, and we confirmed with the person at the tax office here in Tavira, and he said, "Don't worry, it will be fine because the guys are wrong." So I don't know if they are wrong. I tend to think that they are correct, but the system does the opposite from what the law says.
If you make a loss, is that tax deductible?
If you make a loss, it's tax deductible for 5 years. So if you lose money when selling your property, which at the moment it's difficult, you can use that on the next 5 years. That's actually is very interesting because I had a couple of cases last year, and are very unfair. Husband and wife, they've done a lot of works on the property. All the invoices in on the husband's name because it's normal, traditional, so we just put everything on their name. But both of them own the property, and she contributed as much as him. We filed jointly. We put all the invoices together so that and said to the tax authorities, because they are married, it's 50-50. We put everything 50% on hers, 50% on his. They filed jointly. The tax authorities made the tax audits and they said, no, they are married with separation of assets, so the invoices are in his name, only him can deduct it and she can't. He made a loss and she had a gain. She paid tax. He didn't, but it doesn't offset the loss that he made on her gain. and that was really unfair. The client was really upset with that. He now sold another property, and what we said, okay, just put all the costs on her on the next one, because you already have a loss from the previous year that you can use, and your wife doesn't. So if you put more costs on her, maybe you could balance it. But it's a very unfair situation, and it's very common. It's very common that people don't ask for an invoice because the builder will say, if I don't pay you, if you don't want an invoice, I don't charge you the VAT, and you save 23%. Okay, so the invoice was 50,000 euros. You saved 10,000, 12,000 euros. However, when you sell the property, you lost 62,000 euros because you didn't use not even the 50,000 when you sell. So that's one mistake, because people think I'm saving 23%. The capital gain tax is not going to be that much. Yeah, but the capital gain tax will not consider not even the 50,000 because you have no invoice. There's nothing to deduct. And the second mistake is very common again, is for people to get the invoices all on the name of the husband or all on the name of the wife. And then we can only use some of them, or we can only use all of them in the husband, and he makes a loss and she makes a gain, and they still pay because one doesn't offset with the other.
Can you spread that loss over previous income years, or is it only an applicable year you sell it?
No. If you make a sell, the transaction is only reported in the year that you sell. But if you make a loss, then you have 5 years to use that loss. That's automatically. If you sell a property within the next 5 years, that loss will be deducted from your tax. Only in Portugal, or in, sorry, the reinvestment?
Is the tax deductible on income only in Portugal, or
No, it's
Europe?
it's only in Portugal, and it's only income of the same nature. So next year, so this year you made a loss on the property, and you have a capital loss. That loss is going to be reported for the next 5 years. Next year you have a gain because you sold some shares. That loss is not going to be offsetted because it's not the same type of income. It needs to be, it's only if you sell another property. So shares, losses with shares, with gains of shares, and losses of property with gains of property for 5 years.
How about property in other European countries?
Sorry?
Property in other European countries.
Property in other European countries. If you have a loss, normally, that is also deductible within the next 5 years, because it's the same principle when you lose money on shares or financial assets. If you make a loss, you can use that loss for the next 5 years. And the only thing is that if you lost money, so you are a tax resident, right? You are a tax resident, you declare here your worldwide income. You made a loss on a property in the Netherlands. That loss is reported on your tax return in 2022, let's say. When you make a gain on your tax return 2023 on a property in Portugal, that loss is going to be deducted. As long as it was deducted last year and it's on the tax bill as a loss. There was a lot of questions. I have some questions here that I think we didn't cover. Richard is looking at me because that's something that he's been talking about since we met, I don't know, 5, 6 years ago, about the rates from Tavira Verde. Because as you all know, some of you that have a local lodging license, you rent, even if you just rent it for 2 or 3 months of the year, you pay a lot more Tavira Verde, a lot more fees, because Tavira Verde automatically changed their tariff to commercial instead of domestic. I spoke with a client in Olhão, because Olhão does exactly the same thing. Lisbon does exactly the same thing, and most of the municipalities are doing that. So what used to be just 2 or 3 municipalities doing it, now it's a lot of them are doing it. But I spoke with a client in Olhão that he has an AL, and he rents the bedrooms within his main residency. So he uses as his main residency. He showed that to the Ambi Olhão, or whatever it's the name of the company, and they switch it back to domestic tariff. So if it's your main residency, and if you rent as an AL, but it's your main residency, we can try to see if the license is bedrooms, that you can try to get back to the domestic tariff. But that's the only case that I know. I heard people saying that they would try to do a collective action to do something about this, but I think that's something that it's not possible, because most of the it's happening in most of the municipalities. They just switch your contract to commercial, and that's it. I don't know if anyone has more questions. I said at the beginning that I was going to spoil your day, and I was really sorry for that. So there's not really anything here within this law package that is good. We think, me as an accountant and people that are here that do property management and property rentals, it's very unfair, and it seems like the government is targeting at a group of individuals. I understand that it's also unfair for the locals. If they try to buy a property or rent, there might not be enough properties available, and the rents are very high. But this was always the case in the Algarve, because this is a touristic area. When I was 23 years old, I married. We do stupid things when we are young. And I remember we used to, on the property that we were living, we used to come out in August and July to rent it. So there was no Airbnb, but at the time it was common that it was still difficult to have a house, and there was the same problems. Obviously, the magnitude now is higher because of all the portals. But what happened was that if you go back on time, Tavira in 2013 or 2012, or if you go to Lisbon on Porto, the town center, all the houses were falling apart. Nobody wanted to live here. People wanted to live in cabanas or where the new houses were being built. And the center of the cities in Porto, in Lisbon, Faro, some of them look like Beirut. It was really bad. The government created the AL. At the time the AL started, people were paying 3.75% tax. There was an opportunity there. Only 15% of your income was taxed, so there was an effective rate of 3.75. So people started to invest. The properties became nicer. The center of the cities much more attractive than they were before. Because of all these investments, the golden visas, the Airbnbs, etc., because people were buying the properties to get some return. Then the government said, okay, we're going to tax you more, and we're going to tax you 8.75%. It's not a lot, but it's more than the double that people were paying. So if they were paying 3.75 and then suddenly 8.75, it's more than the double. And then it came 2019. We have clients that have properties in Lisbon, and they said, from now on, this is a containment area, and you're going to pay tax on 50% of the gain and on the income, and not 35%. So again, another increase. And you cannot transfer the license. So it's like, then they started with the touristic taxes. You pay the touristic taxes in a lot of places. In Olhão, Tavira is not yet, but you pay it in Lisbon, Porto, etc. So, and now this, where you get the CEAL. So it's obvious that people are saying, oh, but I want to live in the town center. Yeah, but 10 years ago you didn't want to because there was no properties available there. And now you want, and now the government is really targeting at especially the apartments and saying, okay, this is where we want to go. The villas is okay, people can stay in the AL, but if you have an apartment, we're going to tax you, and we're going to make sure that it makes you attractive to either to move to the long-term lets. And my opinion, it's not going to work.
Yeah, Ricardo, I heard that some folks are using the AL through a rental company.
Yep.
Can you summarize what the pros and cons are of that approach?
Okay, there are different setups, okay? So you get the AL in your name, you rent direct, you manage, you do the invoice, it's all done for you. You have the tax liability, you pay tax based on, in your case, 50%, but in most cases, 35% of the gross income. I can also give it to an agent, and the agent rents it to the guests. Normally, in that case, if the license is in the name of the agent, I can either have category F of income, so it means that I'm receiving a rental income, and in that case, it's not a business, it's not affected by CEAL, it's not affected by capital gains issues, etc., the Vida Verde, but the agent will have, because they hold the license, they will pay the CEAL, so I'll have to pay it anyway. And I pay the tax at 28%, now 25%, of the income that I receive from her, the agent. Alternatively, the agent could do it differently. They could have the license in their name, and I'm still a business, and I invoice them, and they own the license, and I invoice them for the money that I get paid. A third option, which is also used by many rental agents, I own the license, but because it's the agent doing all the check-in, check-out, the bookings, etc., to make it simple, the agent invoices directly to the guests, and I invoice to the agent. So it's still a service. The CEAL falls under my name, and I invoice the agents to get paid every month. So all these setups are possible as long as the requirements are met. You have the different options. If you have, there's pros and cons on all of them.
But if the AL would be in name of the rental company,
yeah,
would that then eliminate the capital gains for a company structure?
If you are not registered as business income and it's category F, yes, because you're not the operator, you're receiving a rental income. But in that matter, that's only possible if you are paying more tax. So you've been paying 28% of your income instead of 8.75%. So in most cases, people prefer to have a business because you pay a third of the tax. The only thing is that when you sell, you need to wait 3 years to sell, or change it to the rental, to the long term for 3 years and then sell. Dennis, over there.
Sticking with the license in the name of the agent and not in the name of the apartment. If I have an apartment, the license is in the name of the renting company. I sell the apartment. What happened to the license since I don't own it?
The license is not transferable, so it relates to a property. So I don't know if they will be able to check, but with this CEAL procedure, they might, because the CEAL, it's in the license always refers to one property. So if it's in my name, which is the owner, or in your name, which is the agent, it doesn't matter. It's not transferable. So you sell the property. The agent should cancel the license, even if the new owner wants to continue with the business. They should cancel, because whether the system is going to pick it up, I don't know, but I would assume it will sooner or later, right? Is everyone okay then? Robert?
Yeah, Ricardo, I'd like to thank you very much for today. I learned a lot how it should be done. But what I'm always wondering about is, what happens if you rent out without an AL license and you get caught? What are the consequences?
You pay fines. But we all know that there's a lot of that already. But you pay fines if you advertise for short-term lets without having the AL license. And I would be very careful, because the tax authorities, they receive information from all the portals, even Facebook, even Instagram now. There are rules in place where they receive the information. They don't know how much you received from Airbnb, but they know that Airbnb has been making payments to you. So if you don't declare, or if you under-declare, it's traceable. Same way if you are selling things on Facebook, if you make more than X number of transactions per year, they now need to report it to the tax authorities. There was an article the other day in an American paper they were talking about this problem in New York. And the government, I can't remember exactly what they did in the US, but they limited in New York the rentals for the number of nights that you can rent it to Airbnb. And what happened was that there were pirate portals that were created that don't communicate with the tax authorities, and people started to use alternatives. But obviously, all these alternatives have risks, because the risk, it's not even the tax. The tax, you could have everything legal tax-wise, but then the ASAI, which is the police that comes to investigate the economic activities in Portugal, if they come and they see that it's not legal, that you don't have all the legalities, all the formalities, they can not only stop you to rent, but the fines could be massive, much more than the tax authority. So it's a big problem. We were also talking during the coffee break. My colleague was telling me that in Olhão, I'm not sure if it was Olhão, they were asking for the public liability insurance, and they were notifying the owners of that requirement. And what we were saying is, it happens very often. So the client has a house in Castro Marim, but he never goes there because it's always rented. The council notifies the owner through post. Normally it's by post. They not even pick the letter because they were not there. And the notification was to show something, for instance, the public liability insurance. And they lost the license because they not even acknowledged that it was missing, and they not even received the post. So always have a rental agent or someone checking on the post to make sure that you are aware of all the notifications. Well, I think that's all. Thank you very much for coming. Yes? Yeah. Don't forget that everyone that has an AL needs to confirm the AL before the 6th of December. If anyone, villas or apartments, if that's not done, the property could lose the AL.